Judgment in the appeal, proceeding against Taylor.
Lord Sumption will give the judgment of the court.
In interpreting a statute creating a criminal offence, the courts usually presume that the offence can be committed only if the person accused was in some way at fault. This appeal raises the question whether fault was required for the specific offence of aggravated vehicle taking, and if so, what sort of fault. Section 12 of the Theft Act makes it an offence to take a vehicle knowing that the owner had not consented to its being taken. It carries a maximum sentence of 6 months' imprisonment. Section 12A creates what is essentially the same offence but with aggravating factors. One of the aggravating factors is that owing to the driving of the vehicle, an accident occurred by which injury was caused to any person. This is a much more serious offence. If the accident caused injuries from which the victim died, the maximum sentence is 14 years, the same as for causing death by dangerous driving, which is the most serious driving offence in the criminal calendar. The question at issue on this appeal was whether the accident can be said to have been caused by the driving of the vehicle if there was nothing wrong with the driving. Mr. Taylor took a tipper truck from a friend called David Marriott in order to collect another friend from Exeter. The truck belonged to Mr. Marriott's employer. The prosecution alleged that the employer had not consented, and Mr. Taylor knew that. On those facts, there is no doubt that Mr. Taylor would be guilty of the basic offence under Section 12. Unfortunately, as he was driving back from Exeter, he collided with a scooter in the dark on a tight bend. The driver of the scooter fell beneath the wheels of the truck and was killed. After carrying out tests and reconstructions at the site of the accident, the prosecution agreed that there was nothing wrong with Mr. Taylor's driving. He had been driving at reasonable speed. The position of the oncoming scooter was such that he could not have seen him at the time. And although Mr. Taylor was over the drink-drive limit when at the time of the accident, the conclusion was that that had not in any way contributed to the accident. He was charged with aggravated vehicle taking, the more serious offence. The prosecution said that it made no difference that his driving was not at fault. He was still guilty of the offence. The Court of Appeal, Criminal Division, agreed with this. This problem has arisen before, either in relation to the same offence or in relation to similar offences which require that an accident should have been caused by the driving of a vehicle. In one case, a pedestrian was killed when he walked across the central reservation of a dual carriageway and stepped straight out under the wheels of the defendant's car. In another, a driver was killed because he was high on heroin and swerved across the road into the defendant's car. In each of these cases, the accident was entirely the fault of the dead man, but the Court of Appeal held that the driving had caused the death. That was because, although there was nothing wrong with the driving, if the driving had not occurred, the car would not have been in the place where the accident happened. 2 years ago, this court considered this issue in a case called the Crown and Hughes. It was not about aggravated vehicle taking. It was about the statutory offence of causing the death of another person by driving while uninsured. But the issue was very similar. This court held that you could only cause the death of another person by driving while uninsured if there was something wrong with the driving which contributed in a significant manner to the death. In the present appeal, the Supreme Court unanimously holds that the same principle applies to the offence of aggravated vehicle taking. If there is nothing wrong with the way in which the vehicle is being driven, then it cannot be said that the driving has caused the injury or death of the victim. It follows that the decision of the Court of Appeal must be overruled, and a declaration will be made that Mr. Taylor cannot be convicted of aggravated vehicle taking on this basis unless there was some element of fault in the way that the car was being driven, which contributed in some substantial sense to the accident.
The court is adjourned.